Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 81. This week we're going to be looking at two EAT decisions and one decision from the ECJ. And the first EAT decision considers whether it was fair to dismiss an employee for offensive and disparaging Facebook comments about his employer made 2 years prior to his dismissal. What's particularly interesting about the decision is the employer had known of the misconduct during this period and still the EAT concluded the dismissal was fair. Secondly, we have an EAT decision regarding the rights of agency workers in respect of the provision of information about job vacancies. And thirdly, the ECJ decision looks at whether the parental leave legislation in Greece is contrary to the EU laws on parental leave and equal treatment. And whilst the decision does not directly impact on UK law, it is being suggested that it gives insight into the European Court's approach to parental leave rights and a possible direction of travel for UK shared parental leave. We'll see. So, first case, British Waterways Board and Smith. This is an EAT decision concerning an employee who made derogatory comments about his employer on Facebook, and some of them were, it has to be said, pretty derogatory, although he said they were banter only. The EAT considered whether it was fair to dismiss the employee despite being made aware of the misconduct a number of months before the dismissal took effect. By way of brief background, one of the requirements for a fair dismissal, just as a reminder, is that an employer's decision to dismiss must fall within the range of reasonable responses that might have been adopted by a reasonable employer. In assessing the reasonableness of an employer's decision, the tribunal must not substitute its own view for that of the employer. And it was this point that the EAT paid particular attention to when it made its decision to overturn the tribunal's earlier judgment in this case. Mr. Smith worked as a manual worker for British Waterways. He worked on a rota pattern and was on standby for 1 week in every 5. Whilst on standby, employees were not permitted to consume alcohol. During Mr. Smith's employment, he raised a number of grievances against colleagues, and a mediation meeting was arranged to address these grievances. However, in the run-up to the mediation, Mr. Smith's manager disclosed some derogatory Facebook comments to the employer, and these were comments that Mr. Smith had made about British Waterways and Mr. Smith's managers some 2 years previously. There were also Facebook posts that showed Mr. Smith bragging, allegedly, about being, quote, half-pissed, unquote, whilst on standby. Interestingly, British Waterways, through its personnel, had known about these comments sometime before the mediation. Mr. Smith's manager had become aware of Mr. Smith's behaviour almost 2 years earlier in relation to these Facebook postings, and had discussed it with the HR team, who had failed to raise it with Mr. Smith at the time or investigated any further. British Waterways claimed this was because they were so busy they just didn't have the time to do so. Mr. Smith was suspended from work pending an investigation into the Facebook comments that had been uncovered, and he was later dismissed for gross misconduct. British Waterways' disciplinary policy provided it could dismiss employees for improper misconduct and forbade, quote, any action on the internet which might embarrass or discredit British Waterways, including defamation of third parties, for example by posting comments on bulletin boards or chat rooms, unquote. The British Waterways' grounds for dismissal were therefore that the derogatory comments were made about British Waterways as an employer, and the claims of drinking alcohol whilst on standby brought his capabilities into question, leaving British Waterways open to public condemnation. Mr. Smith's internal appeal was unsuccessful, and he brought a claim for unfair dismissal to the Employment Tribunal. And although the Employment Tribunal held that the British Waterways had followed a fair procedure, the Employment Tribunal found that Mr. Smith had been unfairly dismissed, as British Waterways had failed to take into account any potentially mitigating factors. These included, they said, Mr. Smith's unblemished service record and the fact that both his manager and HR had been aware of the comments for some time and failed to act upon them. Equally, the consumption of alcohol whilst on standby had no effect on Mr. Smith's performance in the circumstances, said the tribunal. There had been no emergency on the night in question, and therefore no risk to life or property, and the tribunal therefore ruled that the decision to dismiss fell outside the band of reasonable responses, which a reasonable employer might have adopted, and therefore Mr. Smith's dismissal was unfair. But the EAT disagreed, finding that Mr. Smith had been fairly dismissed, and I'm going to come back to that. They did not remit the matter to be reconsidered. In coming to this conclusion, the EAT held that the tribunal had unfairly criticised the disciplinary manager's approach to the mitigating factors. The tribunal had essentially substituted its own views for that of the employer when it held that British Waterways did not give weight to the mitigating factors on Mr. Smith's dismissal. The EAT considered that the tribunal had insufficiently defined Mr. Smith's behaviour as misconduct, when in fact British Waterways had found his acts amounted to gross misconduct. So, point of note in this case, it's the EAT's approach to when the incident occurred. There's no criticism of British Waterways for taking Mr. Smith's behaviour into account and relying on misconduct that had been committed some years previously. Misconduct which it had been aware of for some time too. And to this extent the case is different from the Leeds football case that I did in an earlier podcast, where although the comments had been made some time ago, they'd only come to the employer's attention very recently. Equally here, the EAT did not comment on how British Waterways had obtained the Facebook comments, i.e. through Mr. Smith's manager, accessing them online. And that could, if you were cynical, and I don't know whether this was the case or not, but that could be portrayed as searching for evidence against Mr. Smith to fend off the grievances raised by Mr. Smith. The reasons given by Mr. Smith's manager for providing the information at the time, as opposed to a year or so earlier when he first learnt of it, was that he wished to demonstrate to his employer that the mediation was not all about one-sided criticisms. Instead of focusing on the how and when, the EAT focused on the fact that the tribunal had incorrectly substituted its views for those of the employer and incorrectly made its own findings of fact, for example, by inferring that drinking whilst on standby did not actually present a risk. Given that British Waterways Board had been found to have carried out a procedurally fair investigation, the EAT concluded that dismissal could only be held to be fair. The EAT held that Mr. Smith's behaviour undermined the trust and confidence between employer and employee, and not only was it a clear breach of policy, his acts had also left British Waterways open to public condemnation. The EAT therefore held the decision to dismiss was fair, even though the comments had been made by Mr. Smith 2 years ago, and British Waterways had known about them. The EAT said they saw no point in remitting the case to a new employment tribunal, saying the tribunal had erred in law, and there was only one possible definite answer, and that was that the dismissal was fair. Well, the EAT case is an important reminder to employers to ensure social media policies are well drafted and expressly set out social media expectations are for employees, particularly where they expect the policy to extend to the employee's social media behaviour outside the workplace. Having a well-drafted policy puts the employer in a far stronger position when an employee has misused social media, and this is of particular importance increasingly these days given the rise of social media networks, etc. And the case law landscape continues to indicate that this is a very fact-specific area of law. Although definitely not a recommended approach, this case also demonstrates that where an employer has failed to take action in respect of an employee's alleged misconduct or has delayed responding to it, that does not necessarily mean they will lose the right to take action in respect of that at a later date. Whilst we would always advise that employers take prompt action in response to misconduct, in this case Mr. Smith's misconduct was 2 years prior to dismissal, and the employer had known about it for a considerable part of that time. However, the EAT did not really appear to criticise British Waterways for this delay, and similarly, they didn't really make a point of addressing how British Waterways came to get hold of this information. Often, tribunals have viewed acts like this as fishing expeditions carried out by employers in search of a reason to dismiss. Employers do need to tread carefully when taking such an approach, as they risk an employee claiming they're being victimised for bringing a grievance, or that there is a breach of the whistleblowing legislation. This is essentially retaliatory action. Here, it's noteworthy the individual's whistleblowing complaint was rejected by the Employment Tribunal, and there was no appeal. I think overall, I do have a lot of sympathy with the EAT's decision on the way the tribunal assessed the risk inherent with someone drinking on duty and its potential harmful effect. That was surely a matter for the employer, provided it wasn't taking a manifestly unreasonable view. Similarly, the tribunals before have shown themselves relatively unconcerned as to how parties come by relevant evidence, assuming it's not privileged. However, I do think the fact that the EAT took such a strong view of the facts of this case and really brushed aside the significant delay in raising these matters with the employee concerned made the employer really very lucky to have got the finding that the dismissal was fair and not even a remission back to the Employment Tribunal to consider the point further. So, that's the case of British Waterways Board and Smith. On to the other EAT case, that's Coles and the Ministry of Defence. This EAT decision looks at the scope of protection for agency workers under the UK's agency regulations, and behind them the EU Agency Workers Directive. In particular, this case looks at the extent to which agency workers have the right to be informed of job vacancies and how far employers have to go to treat agency workers the same as permanent employees. Had the case gone the other way, it would have amounted to a very significant extension of the rights under the directive. Let's start with the background. The EU Temporary Workers Directive provides that agency workers must have the equivalent basic working and employment conditions of that of permanent employees in relation to certain specified types of term. Furthermore, the directive provides a right for agency workers to be informed about vacancies at the hirer. The EU directive is transposed into English law by the Agency Workers Regulation 2010, and Regulation 13.1 says an agency worker has, quote, the right to be informed by the hirer of any relevant vacant post with the hirer to give that agency worker the same opportunity as a comparable worker to find permanent employment with the hirer, unquote. Well, facts of this case involve an agency worker, Mr. Coles, who was supplied to the Defence Housing Executive, which is part of the MOD. DHE, the Defence Housing Executive, decided to do a substantial restructure, which resulted in 530 permanent employees being placed into a redeployment pool. Those 530 permanent employees were to be given priority consideration for any vacancies arising in the MOD. The post that Mr. Coles had been temporarily filling was advertised internally as a vacant post. This advertisement was visible to Mr. Coles and also to the other employees in the redeployment pool. One of the employees in the pool applied for the post and was subsequently appointed to it. Mr. Coles did not apply for the post. As a result of the permanent employee being offered the post, the DHE no longer needed Mr. Coles' temporary service and he was given notice. Mr. Coles brought a claim against the Ministry of Defence, claiming it had breached the UK's agency workers regulations and the underlying directive, because the Ministry had failed to allow him access to details of the vacant post and had denied him the opportunity to apply for this position. Well, the Employment Tribunal rejected Mr. Coles' claim. The tribunal held that both the directive and the regulations only require the provision of information with respect to vacancies so as to confer opportunities for potential applications. It does not necessarily confer the right to actually apply for such a position. Ultimately, the tribunal found that neither the regulations nor the directive require an employer to displace existing permanent workers by offering temporary agency workers the right to compete with them for a permanent post on an equal footing. The regulations and the directive permitted an employer to give priority to permanent workers who were potentially going to be made redundant, with a view to giving them priority in the search for alternative work. Mr. Coles appealed to the EAT, and the EAT dismissed the appeal. There are two main findings. First, the EAT hold there is no general right for agency workers to be treated no less favourably than permanent employees. Rather, the principle of equal treatment in the directive and the regulations was confined to basic employment conditions, respect of working time, pay, that sort of thing. The position of agency workers is not equated in law with the position of permanent employees. In fact, the EAT said, both the regulations and the directive note that agency workers are part of a framework which allows employers to have a flexible workforce. So there's no basis in principle for protecting the job of a temporary agency worker in preference to that of an existing permanent employee. Secondly, they said, whilst it's clear that the directive and the regulations provide agency workers with the right to information at the same time as is provided to the permanent employees, that right is valuable in and of itself, and the right is to give agency workers the same chance as other workers in relation to finding permanent employment. It does not say anything about the way in which the employer goes about choosing who it wishes to offer the job to. Therefore, if an employer wishes to give preference in terms of job offering to permanent employees in a redundancy redeployment pool, the employer is fully entitled to do so. The law in this area focuses on the equal provision of information about vacant post. It doesn't go the step further to require equality in the job application process. That being said, it's clear the law requires that the provision of information to agency workers and permanent employees must be on the same basis, i.e. they must be informed of the vacancy at the same time, same date. That's the extent of the right. So overall, I think the case, it's a useful reminder of the narrow extent of protection given to agency workers under the law. It's important to remember that the regulations in the UK give temporary workers equivalent rights to comparable permanent employees only in respect of working hours and pay. They don't have the more general right to equal treatment. And this is because it's clear that temporary agency workers can legitimately be used as a form of flexible working. As such, any attempt to extend the rights of agency workers could cut across that clear aim. I think the decision is going to be a very welcome one for employers, as it confirms that the rights provided to agency workers under the regulations are relatively narrow. I think this is also a sensible decision, as it must be right that permanent workers in a redeployment pool can be given priority over temporary agency workers. Certainly in my experience, it would be most unusual for an employer to give a vacant post to an agency worker and make a permanent employee facing redundancy take a redundancy payment instead. So, third and final case, and here we have another of those names. Check it out online. I'm certainly not going to attempt to give you the full Greek name. I'm going to say it's the Maistrelis case, Maistrellis. Actually, I should just issue my normal reminder at this point that, of course, if you want the case links and the case names, then please do follow me on Twitter, because I post the case name and links on my Twitter account, Nicholas Robertson at Nicholas ROBER, and then the number 1 and the number 1, Nicholas Robber 11, and that will get you the links. And the other way of finding out the case names is to follow us on YouTube, where again the case names appear during this podcast. Anyway, Maistrelis case. This is the ECJ decision I mentioned earlier, which considers whether the parental leave legislation in Greece is contrary to the EU parental leave and equal treatment directives. Whilst the decision itself does not really directly impact UK law, it provides an insight into the ECJ's approach to parental leave rights and possibly raises the question of whether the UK's shared parental leave legislation is compliant with EU law. Spoiler alert coming up. I don't think this case is as significant as it's being portrayed by some people in the press, and certainly I don't think there is any need for employers at the moment to take any sort of anticipatory defensive action. And if anyone ever does get a legal challenge based on this case, I'd love to hear from you. So, background facts to this case are straightforward. Under Greek law, female civil servants are entitled to 9 months parental leave. However, male civil servants are only entitled to parental leave if the mother of their child works or exercises a profession. Mr. Maistrelis was a male civil servant, and he applied for parental leave in respect of his young daughter, but this was turned down because his wife was not employed. As such, Mr. Maistrelis brought a claim in the Greek courts that Greek legislation was contrary both to the EU Parental Leave Directive and the EU Recast Equal Treatment Directive, and the Greek court made a reference to the ECJ. Well, the ECJ found that the Greek legislation contravened both the Parental Leave Directive and the Equal Treatment Directive. The Parental Leave Directive implements the Framework Agreement on Parental Leave, which grants men and women, workers, an individual right to parental leave of at least 3 months until the child reaches a certain specified age. Importantly, and as I will explain in a moment, I think there's a key difference between parental leave under the directive and shared parental leave, which is a UK term, and I'm going to come back to this. Anyway, the ECJ held that the parent cannot be deprived of the right to parental leave on the basis of the employment status of their spouse. Importantly, the court went on to say that the situation of a male employee and a female employee parent are comparable as regards the upbringing of children. Therefore, the position under Greek law in relation to parental leave, i.e. treating fathers less favourably than mothers as regards the entitlement to parental leave, was also direct discrimination on the grounds of sex. It tended to confirm that men were less involved with parenting duties than female employees. Pausing there, it's important to consider the position under UK law. Unlike Greek law, the UK legislation complies with the EU Parental Leave Directive, as it allows the minimum 3 months unpaid leave for men and women on an entirely equal basis. So, to the extent that there is an issue, the key issue from a UK perspective is the court's pronouncement on the fact that, in relation to parental leave, treating fathers less favourably than mothers was liable to perpetuate the inequality between men and women, because it keeps men in a subsidiary role to that of women when it comes to exercising parental duties. I've seen commentary that indicates this case forms the basis for challenging the shared parental leave rules in the UK. In particular, can the new legislation which has introduced shared parental leave in the UK be challenged on the basis that it's now contrary to EU law? Well, under the shared parental leave regime, any parents, father or mother, seeking to take shared parental leave must first show that they have a partner who is in some form of employment. I am simplifying the rules slightly here. Therefore, a parent cannot take shared parental leave if, broadly speaking and subject to exceptions, their partner doesn't work. However, under UK law, a mother whose partner doesn't work has a right, in any event, to take statutory maternity leave of the same length as shared parental leave, whereas a father whose partner doesn't work is entitled to paternity leave of the same length and pay rate as shared parental leave. So in other words, women who work always have maternity leave, may have shared parental leave. Men don't always have shared parental leave. Therefore, ergo, maybe not, there is disparity in treatment between the sexes. So that's why there is arguably a similarity with the position under Greek law, because the father may not be able to take the equivalent amount of shared parental leave as a mother when the factual situations are comparable. However, I think the argument that this opens the door to a challenge on the UK's shared parental leave regime is overstated. First, in the UK, we've had paid maternity leave and the right for a woman in work to get paid what is currently 39 weeks paid leave and up to 13 weeks further unpaid leave. We've had that for many years. Courts have recognised there are specific health, etc. reasons for allowing a woman a period of paid leave after childbirth. Secondly, the government's shared parental leave scheme is a system by which a woman can elect to transfer some of her maternity leave to her partner. And for present purposes, and again, because I'm simplifying this, let's assume that partner is a man. Under the European parental leave process, the issue was that women had a right to a form of leave in circumstances where a man did not. Here, in the UK, for shared parental leave, we have a single right, which is capable of being shared within a family unit. So in essence, you have a right given to a family to be divided between the man and the woman as they see fit. So first point is that unless it is inherently discriminatory to give women in the UK statutory paid maternity leave, then we're talking about a fundamentally different situation between the UK's shared parental leave and the Greek unpaid parental leave. Secondly, the UK's shared parental leave is expressly about not perpetuating the traditional distribution of parental duties by allowing men a greater opportunity to participate. Whether you're in favour of it or not, whether you think it'll work or not, we can't really argue that that's what the aim of it is to stop the automatic assumption that women will take a year off work to look after children, where the parents want a parent to take time off work to look after their children. As I say, there's been a certain amount of comment on this, but I, as you can tell, definitely fall into the sceptics camp on this one. And it has absolutely nothing to do with the fact that my youngest son turns 18 in January, and so any hope I ever had of taking parental leave, paid or unpaid, is fast disappearing. So, there we go. That's the case of Maestralis and a very long and unpronounceable Greek name. Thank you very much for listening, as always. And as always, I confirm that no employees were harmed or mistreated in the making of this podcast in any way. Thank you very much for listening. Goodbye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.